waiting for my cue. That soundtrack gives me the energy, but I can't hear it. But it's okay. Show must go on. It is live. And of course, we are now in session. The summit o'clock it is. And I hope that you are doing well from wherever part of the world you are watching us. We come to you live each and every Wednesday. And of course, our aim is to scale those heights, to be able to give you some of those important conversations and give you an opportunity to actually also hear from those who actually have something to say about them as far as panelists are concerned right here. It is the 15th day of the month of November. And of course, I can see someone behind me. And this is a sign that we are live across all the digital platforms. You can check us out on YouTube. The live stream is out there. And if you want to be part of this conversation or you heard about it and you feel there's someone who must watch this, someone who needs to hear the conversation tonight, please share with them that link. Let them join the conversation. On the X platform, you can also get us right there. All you need to do to be part of the conversation is add the hashtag #TheSummitRW. As always, my name is Eugene. And Nangwe, thank you so much for making time and, of course, for joining us on the program. Tonight on the show, we have a very interesting conversation, and this conversation is around looking at the alternatives towards the issue around resolving, issues that are criminal in nature in that case. And, of course, we're taking a closer look at the dispute resolution and justice policies right here in Rwanda. It's a journey that started all the way, I think, around 2012, and earlier this year, there was actually an unveil of some of those policies. And we want to go deeper into these policies. And of course, alternative dispute resolutions is not something new. Of course, from a traditional perspective, we have solved some of these problems from that particular angle. But we want to understand the changes that we continue to see across societies, how best can policies or the laws actually enshrined in terms of helping in resolving these disputes? How far can we go? What cases actually are allowed to be resolved from this perspective? Does it hold water? I had an issue with so-and-so. We went ahead and resolved it through other mechanisms without going through litigation. Will that hold water, in whatever case that is? So I want you to be able to be with us tonight on this particular conversation. I'd love to hear from you if you have any case that you've sorted out through alternative dispute resolution mechanisms. How was your experience? Is that person now your friend, or actually it added salt to the wound? Talk to us, and how best can this be strengthened as far as policy formulation is concerned. But before we go even further, I want us to set the tone for this conversation, and I want us to take a look at this testimony on this particular video, and then we'll be able to come and introduce our panelists on the program tonight. Let's take a look.
Mfite ikibazo n'umugabo witwa Kabera. Umugabo witwa Kabera yaje iwanjye, mbega turicara aratangira arambwira ngo bibi nguza amafaranga ngenda ayikeneye. Unguza ngase unguze nk'ibihumbi 500 ndabikeneye, ari bintu nshaka kugura. Nshaka kugura iki se? Ndashaka kugura inka. Ndayafata ndayamuha. Kimara kuyamuha ajya gukora ibyiwe. Amaze gukora ibyiwe, bo amafaranga nangiye kumwishyuza akazasuzugura akambona ko ndi igicucu, mbega ko ndafite ubwenge. Yewe wamaye amafaranga akambona bure kabisa, akamara akambona bure, akamara ko ndafite ubwenge. Nyuma yaho ndareba uyu muntu nagiye mu bunzi kumurega koko. Kuno hari abunzi nagiyeyo. Ngo manuka ahantu hitwa mu Kanyogo. N'abunzi bakorera. Ngeze ku bunzi ndayibabyira, maze kuyibatekerereza. Ubwo amba convocation ndayifata, nyoherereza Kabera nawe aza kuza aritaba. Amaze kwitaba avuga ibyiwe, amaze kuvuga ibyiwe, ubwo abunzi batugira gute? Aratubwira ngo mwembi babiri turabashaka, batujyana mu cyumba, mbega baratuganiriza, batugira inama ku byagenda. Bamaze kutugira iyo nama, uwo Kabera iyo nama arayumva, amaze kuyumva aragenda. Nyuma y'ibyumweru 2 anyohereje 200. Turicaye nyuma kandi y'amezi 3 bonambaye ibindi 300, deni rirarangira. Aho kuva tuva mu bunzi na baratwuze kabisa, ubu tumeze neza nawe. Kera by'Abanyarwanda uzazugira ikibazo aze yihutira ku bunzi babunge. Nk'ijya atashaka kumvikana na mugenzi we ajye ku bunzi babunge.
Right. That was a testimony right there, of course, trying to exploit or explore the uptake of mediation in terms of alternative dispute resolution. I want us now to get deeper in this particular conversation tonight after setting the tone on that video. I want to introduce my panelists on the program. I have Nawahire Anastasius, the Director General Justice Sector Coordination at the Ministry of Justice. Thank you so much for making time, sir.
Thank you, sir.
Also with us is Uicheza Bernadette. She's a mediator and a founder of Mediation Home Rwanda organization. Thank you for making time.
Thank you, sir.
Also with us is Jean de Dieu Kairanga, Program Analyst at the UNDP Rwanda. Thank you for making time.
Thank you, sir.
At least I feel I'm in a very safe environment, because if we were not able to agree, the three of us, we have a mediator in the middle, and we'll be able to sort out whatever disagreement we have.
We have many.
We have many. Thank you very much. So let's get into this conversation. I think the aspect of alternative dispute resolution, I want to understand from a layman perspective, when we talk of alternative, it means there are other alternatives, there are other options. And I want to start with Deje here, because this is something that touches on the Ministry of Justice from a policy perspective. Yeah. Why is there a push for this? What is driving the push for alternative dispute resolution mechanisms to be adapted by a lot of us within the Rwandan ecosystem?
We may say that there is not only a push, there is a necessity. There is a need for peace. We need to build in peace between individuals, between groups, within the community, to make sure that we build a peaceful country. And when you have a peaceful country, people get ready to vacate to production activities. People get to building relationships and ensuring welfare. Yeah. So it is very important that instead of taking much time struggling or let's say fighting each other through litigation in front of judges, people themselves save time, save money, and save relationships, and actually get understanding each other through easy manners.
Yeah. I'll come back to you so we can interrogate that point even further. But I want to hear from Bernadette. Bernadette, what I'm hearing from Deje is sometimes litigation takes time. Yeah. And so it's very easier, or it's much easier to actually seek other alternatives to be able to resolve that particular issue. But traditionally, we've seen people seem to really believe in standing in front of a judge and having the judge hammer and say, "This is my judgment." And that's when people say, justice has been served. And so how do we work towards showing people that other alternative dispute resolution mechanisms can also bring out that closure, can also bring out that feeling of justice being served?
Yeah, actually, during the research that informed the development of ADR policy, many people interviewed said they prefer using those mechanisms that allow people to talk to each other instead of going to court. Because even sometimes they go to court, they do not understand what is going on in the court system, because we have professionals like advocates who say, stay behind, I will talk on your behalf, I am going to represent you. So people appreciate to have voice, and mediation gives voice.
But what about the aspect of feeling that, the judge decides, and if it was not decided by the judge, then I did not get justice? Some would argue and feel that the alternative dispute resolution mechanisms or options might not be long-lasting, might not be binding. That's when you find today we fixed it, but again you've repeated. Yeah. But I feel I should take you now to court.
Now what in our legislation, when there is a discussion, a facilitated negotiation by a mediator, and the parties reach their own resolutions, their own solution, a win-win solution, this solution is by the law enforced as a court judgment. So there is this security. Yeah.
Right. So we'll come and actually understand that much better in terms of how and what is the process and who are the mediators in this particular case and what qualifications do they need to have for you to be able to use them for this resolution. I want to understand from Jean de Dieu, from where you sit at UNDP as development partners, this is big for you as well because you've also played a key role as UNDP to support in this particular line. But I want to understand from where you sit, what's informing the drive? Because we've heard from Deja says it's not just a push, but it's a necessity. Why is it so, and how, from where you sit?
Yeah, thank you very much, Eugene. I think actually it's both a push and a necessity. And actually which led to UNDP to intervene and to support the Ministry of Justice to develop the criminal justice policy and also support the ADR policy. A push why? Because there's that need for the people to access justice. As you know, justice delayed, justice denied.
Yeah.
And the DG also is saying litigation cases take long to process. And when they reach the, what you call the case backlogs, then it's not really fair justice. So there's the need for the push, but there's the necessity. So necessity for people to access justice through mediation. What is actually nowadays the only way to reduce the case backlogs in the justice system.
Yeah.
That was really a need, a necessity for justice sector to embrace this mediation and criminal justice policy. And as UNDP, the tendency was to try to speed up just delivery. And one of the means to speed up just delivery was to implement mediation mechanisms. That's why we came into discussion with the Ministry of Justice and the other justice sector institutions to start, actually even now, the implementation of the ADR and the criminal justice policies.
Yeah, I'm going to come back to you, but coming back to Deja, I know some people might say maybe it's too soon to tell. We're talking about early January, bringing out or putting all these policies to light in that particular sense. But what can you report back so far in terms of these policies? What are they, if we were to put our fingers on them, that would be able to tell the viewer who's watching us tonight, who has had a problem with their neighbor over a certain issue or even family problem, that would be able to tell them, look, like Bernadette said, whatever is decided within that alternative dispute resolution mechanism is still binding, by law. It's protected by law. What are those policies? Maybe let's start there. What are they?
As policy actions, we've been recommended to exactly quickly, starting from the policies adoption, make sure we make a deeper, police awareness. That is a job that started seriously throughout different audiences, touching lecturers into universities, students, local leaders, faith organization leaders, civil society organization members, especially mapping where they are in terms of supporting this process. And what is good is to observe that they started engaging community, they started engaging citizens in different ways and in different matters. And we went through different ministries and public agencies to discuss with the public officials and the staff to let them know what the two policies have as principles and policy actions. And today we are at a level of engaging youth volunteers throughout communities. As of today, we have reached more than 900 youth volunteers that have taken through the policies, equipping them with information to make sure that each of them is able to spread again the information through the same scheme, but also to explain to the citizens wherever they live into umuganda through inama y'abaturage umugoroba w'umuryango. And we intend to continue such awareness. But at the same time, we started exactly looking at different legal provisions that have to be reviewed and changed wherever needed to make sure to facilitate the implementation of the policy.
Yeah.
Together with the UNDP, a good team of researchers has started making a kind of capacity needs assessment to allow us in a few times to develop strategic plans, implementation strategic plans of the two sectors, I mean the two policies. And again, with the support of UNDP, and we hope that other donors or development partners will support the action. But we have started refurbishing a center in Nyamirambo to make sure that in a few months we may have an ADR center.
Okay.
An ADR coordination center, an ADR into which mediation services can be provided. A small scheme of mediation documentation, not mediation, alternative dispute resolution, mediation and documentation and research can be carried out, as well as a kind of M&E to not only provide services, but also be able to inform citizens again, keep an eye on what is going on, exploit good practices and best, success stories, and inform different audiences. We do hope that in a few months, things will be moving.
Right.
Especially from the time we will be having strategic plans for the two policies, from the time we will be having equipped mediators on way. And I may say that in that terms, the country does have now a big number of trained people. And this really is tremendous in together with the judiciary. They have started a training scheme that is successful. That exactly today has helped the country getting more than 400 graduates in mediation. And mediation continued.
Right.
As of now, and even before that, the policy, the alternative dispute resolution policy be adopted, the judiciary of Rwanda had started providing mediation services conducted by registrars and judges wherever they received cases that are eligible to mediation. They were empowered to...
Sorry to cut you short, but the bus is moving. But I don't want us to leave certain people behind. Let's park the bus a bit and onboard a few people who want to understand these policies. What are these two policies? What are the policy actions? So that now they can also be able to understand, so that is the starting point.
Okay.
And this is where we are going.
I get you.
Let the bus continue now.
Yeah. On the side of the alternative dispute resolution policy, the government of Rwanda has given a clear message to Rwandans, saying, guys, litigation is, when needed, is a good thing. And this is why we have exactly set up jurisdictions and the courts. But jurisdiction are important. Courts are important as well as litigation. But also conflicts are part and parcel of the life. But when you look at our history, our culture, when you look at our homegrown solutions, when you look at what we have set as choices of Rwandans, saying one, thinking big, and holding each other accountable, we have to make sure that whatever conflict happens in the country, between individuals, between groups, are looked at, examined, and resolved through some kinds of wisdom that is in respect with our choices. So please, whenever a conflict happens, make sure you do deal with as concerns litigants. And if need be, call upon a both friend to support you in reaching to an agreement that is peacefully negotiated. And when ways are exhausted, then go to court. But please try resolving everything between yourselves or either within the community, exploiting available schemes, or at least inventing some other ways of resolving conflicts, because we can look at our culture. We can look at what we have had, we have already as success stories through homegrown solutions.
Yeah.
But when Rwanda, I used to say that ahari abagabo ntihapfa abandi.
We can even add Nabagore.
Yeah. Well, no. We mean that even abagore, you know, when we say abagabo in that sense, we don't talk of males.
Only a man. Okay.
No.
You're safe, DJ. You're safe. It's okay.
Yeah. So, on the other side, and in respect of the perspectives of our choices, the criminal justice policy came into game to decode Banyarwanda that, guys, we are not angels. And you have laws. And actually, you have penal laws. We have defined crimes. And at all times, you'll be having small, medium, and big criminals. But let's deal with them from now with the purpose of supporting them, with the aim to rehabilitating them. Let's conduct our work into crime prevention, crime detection, investigation, prosecution, processing and sentencing, as well as correction, with aim to rehabilitate criminals, because they are also ours.
Part of the society.
They are part of the society. They are children of our families. They are boys and girls of this country.
Yeah.
We can't leave them behind.
Yeah.
That is the spirit that governs these two policies.
Interesting. Thank you for that. And I want to understand, Bernadette, when someone calls you to mediate, for example, what are usually some of the things that make the other party say, no, I want to go to court? You know, so that now we can be able to start understanding, you know, from what basis do people appreciate or accept the alternative dispute resolution, including the mediation? Yeah, from that perspective.
Yeah. Let me talk about this from the perspective of a judicial officer in a court in Rwanda. When they receive a litigant and the court are directed, judges and other judicial officers are directed to suggest fast mediation, to encourage people to use mediation. Very often people refuse because they don't understand, because it is very new.
Yeah.
They were used since now 60 years to this adversarial system.
Yes.
Thinking it's the best way to resolve problem because there was no other way.
Yeah.
So now slowly, Rwandans are getting on board about mediation. So when they suggest mediation, they just try to understand that they are safe in mediation. And sometimes they are hesitating, uses private mediators because there is a cost behind.
Yes.
And that's why the system we have, the amendment of the Civil Procedure Code of Rwanda in 2018 has provided for mediation by judges and judicial officers.
Yeah.
It's a unique system that is not common in Africa or else in the world. But I think the government of Rwanda wanted the judicial officers, judges, to educate Rwandans and to tell them there is another way. Mediation, it's an opportunity for you to talk to each other, to find your own resolution, and you are supported by the court. So slowly, when they understand that there is another option, they accept. Sometimes they are hesitating because, you are talking to the other person, maybe you are giving him something. So,
correct.
Yeah. But that's why we train mediators to really have the skills to build the trust with parties coming to them.
Yeah, which I'm sure is not an easy thing. Building trust.
It's a skill.
It's a skill.
Yeah,
and we'll talk a bit about that. And from a UNDP perspective, Jean, did you just talk to us a bit about in the kind of support that is available? And probably also speak to the opportunities for those who are watching us tonight. In what ways can they also plug in to support development partners like you in achieving larger numbers of skilled mediators? We heard from the DG saying we are looking at around 400. To some people, they might say that's a drop in the ocean, but others would say it's better a glass half full than half empty.
Thank you, John. Actually, first of all, after the adoption of the ADR policy and the emergency policy, we started by, as DG Answer was saying, by conducting a capacity assessment to understand what are really the capacity needs that will be needed to strengthen the mediators themselves, but also the institutions that will be dealing with the mediation. Mediators are not only at the grassroots level, you're also within the investigation bureau, you're with the prosecution, with the judges, and then the professional and non-professional mediators. So this capacity assessment, which is supported by UNDP and UNICEF and ministries, will actually give us the needs in terms of capacity building for mediation. So that will be like a starting point. And then once we have after the capacity assessment, we'll have a strategic plan or a plan of implementation. That's where we shall really have a tool that will help us to mobilize additional resources to support mediation processes. But also, as DG said, we are trying to establish a center for mediation in Nyamirambo. Of course, you may understand this is not enough. One center in an entire country, it's not really enough. If it could be, like, for example, in every province, or even possible in every district, that will be much better. So it really, UNDP will still need to play a key role in terms of mobilizing partnership for the support of the mediation in Rwanda.
Interesting. Deje, from a situational analysis in terms of the courts, you mentioned earlier on, and I heard from this conversation so far that the idea is to try and reduce the backlogs in the courts. And every time there's something being done, there must be a reason to it in terms of, from a target perspective, what are we targeting to achieve? So probably two parts of this question. What's the current situation in terms of the backlogs? And how do you think, or what is the target for alternative dispute resolution mechanisms in reducing that backlog? What's the timeline? What are you saying? If we had XY number of mediators who can also help with alternative dispute resolution mechanisms, would be able to cut down by X percentage within X number of years, and probably would be able not to have these backlogs within the...
That is a tricky question.
You can do it.
It is a tricky question. I swear. When you look at the backlog, it is a result of some kinds of trust into our court system, let's say into our criminal and court system. Citizens slowly became aware of their rights. Citizens became slowly, enough aware of how justice institutions, being the investigation bureau, the prosecution, court system, and whatever, the way they work, and they became aware of what the crimes are, channels of denouncing crimes, keeping in touch quickly with public officials that deal with the crime and courts. So we have also built a kind of integrated case management system that allows people to even file claims through handsets, which will mean that it is a tool that is good, that is efficient, but that worked against ourselves. So that is why I told you that it is a tricky question. The situation now is that the backlog is evaluated at, first of all, what do we declare as backlog cases?
Yes, yes.
Backlog cases are cases that have spent more than 6 months within a court, once filed, without being dealt with. So we are at a level of 62% right now, which would mean that we are facing something serious.
Correct. 62 is huge.
Absolutely. Yeah. The number of judges does not increase, while cases that are entering courts are increasing.
Yes.
And when you look at what judges do together with registrars, they do a big and good job. Look at a judge who deals exactly with at least between 22, 23, 4 cases within a month. That would mean that at least it is a case per day. When you know them and discuss sometimes with them, if you pick your phone and call one now, you find him in front of his laptop, either analyzing a case or preparing a case to hear tomorrow, or either making a report before signing the decision, which will mean that we have tasks at hand as the judicial system. The country or the government thought of introducing or calling upon citizens and mobilizing them in not only running after justice, but also participating in the process of finding solutions. That is a call that the government made to citizens. We are serving you guys, but support your government to serving yourselves and your colleagues and your neighbors. And this is not strange because it is part of our culture.
Correct.
Yeah. Try avoiding claims, disputes and conflicts. But when some small conflicts happens between you, solve them yourselves because you are capable. That is why we started exactly engaging each of them. And actually, we are not building from ex nihilo, as you say. No, we are building on some good practices that within the community are successful. When you look at the work that is achieved by those we call inshuti z'umuryango, they make tremendous achievements. When you look at what do Abunzi, the same. When you make a look within faith-based organizations, into what Rwanda call imiryango remezo in Catholic churches, when you look at newborn groups, pastors, imams, priests make a good job in terms of building peace and building peace, empowering people in getting solutions from themselves, and it is successful. So we do hope that all of those people will be supported in getting new and basic skills to transform them into professional mediators to support communities where they are and avoid the entrance or the submission of many cases that will be entering into courts. May I give you some percentages?
Yes.
No, it would be risky. It would be risky. I will tell you why. We are in a country in which...
Okay, risky in which way, first of all?
We have tried throughout this National Strategy for Transformation 1. The intent was to see the case backlog reducing.
Yes.
And instead of reducing, it increases. So that is why I would not like to exactly risk in a setting again percentages.
We're trying to find solutions. Right now as we speak, there's someone who's saying, I want to put my hand up to that call to action as a Rwandan to support the government in this case. And that's where I probably want to go to Bernadette just shortly on what
Let's check whether should we give a percentage.
Yes. What's the target? And probably another part to that question, for someone watching us tonight, and they have not had any training, but they've been told by their friends, every time we had conflict, you really sorted the issue out. Thanks to you, my marriage is still intact. And they want to scale that. to a national level and start supporting, from what Deja has said, we would love Rwandans to also support their government in actually solving these problems as mediators. What is required? What's the minimum requirement for a mediator?
I would say it's a tricky, like Deja said, because somehow Rwandans, we are all mediators. But what we saw during the development of the ADR policy, what he was missing were skills and guidelines. Of course, mediation, it's a process that was used traditionally in resolving disputes. But our elders who were providing the mediation services are no longer there. There was no transmission of the skills. So, and we realized that when people get some skills, because mediating, facilitating a negotiation, there are some competence you have to have. And the feedback we are getting from people who went through the program, our training program, being staff of Ombudsman office who went through this program. And the feedback is that now they start communicating, telling people that mediation is indeed the best way, and even changing the way they are dealing with the approaching rights. They are using more mediation skills in that. And now it seems people come to the office of Ombudsman saying, we want you to mediate us. They're not coming, we want you to help us write a claim against our the other party, but we want you to help us meet and discuss and find a resolution. So there is a paradigm shift. Slowly, things are changing. So we have mediators when how the scheme, the court mediation is organized now. Parties in court can be mediated by a judge, a court registrar, or a private mediator, a mediator in private practice. So because the law said we need also a mediator in private practice, I think the idea was slowly to
open up
and to diminish the workload on the judges and registrars. For some cases to be mediated by private mediators, and the judge focus on complex cases that cannot be mediated. So we started training those people can be private mediators. The program started in 2018 with a small number of people, and slowly we had people coming on board from other public institutions, from the local government, local authorities in charge of handling citizen complaints. So the program is reaching more than those private people who wanted to do mediation in private practice.
But before you go again, the bus has to again wait for some people. How do they join? What's the plug? You said there was an opening for private mediators to also come in. If there's someone tonight who wants to join and become part of that list of private mediators, what do they need? What are the basic requirements?
The basic requirements are it's a requirement to have undertake a training in professional mediation. And that's why there is this program, mediation capacity building program with the judiciary. This program is implemented in collaboration with an organization from USA, organization of mediators who have been in practice for many years, more than 30 years. And because we want to learn from on the shoulders of those who have skills, But this program is also contextualized. We are not using only this program material from America, but we have a local faculty team, and Deja is part of this local faculty team. Then we organize sessions, and after 3 months, if they achieve certification, they can ask the judiciary to be admitted to the panel of court mediators.
Okay.
This is the process.
Right. Interesting.
And it's a program that is under the oversight of a committee we have within the judiciary, a court mediation advisory committee that is composed of stakeholders, mini-jus, private sector, other ADR providers, the civil society, to oversee the development of mediation, not only in the court system, because the judiciary is also encouraging people to try mediation even before filing in the court.
Interesting.
Yeah.
I'll come back to you, but let me go back to Jean de Dieu and just try and understand if there was a silver bullet to fix the issue of capacity building in ensuring that we have more trained alternative dispute, those who actually deal with that particular aspect, what would it be from where you sit? Maybe some of the things you've been trying to say, look, we need to do things this way. And probably now you want to say that to a larger audience that can also come in and support. What would that be?
No, I think the implementation of the ADR policy, will require some capacities.
Yes.
First of all, it's something which is very, very new. And it's very different from the past where we used to really rely on the community mediators. That was the one that were really known. But now with the new ADR policy, whereby the investigation bureau have also this mandate to mediate, where the prosecution can mediate, where the judges can mediate. There will be skills that really link it to the needs of each institutions.
Yeah.
And that's why the capacity need assessment will be very crucial
very key,
in terms of identifying the real needs of each institution, because the plan of implementation will also define who will do what. And that will go with the capacities that will be needed. Also, I also thought of what we see as a cross-border crimes that can also be mediated. That we can use mediation to mediate them. That also requires understanding the cultural differences between the cross-border crimes.
It's going to be an interesting one.
Yes, including the cultural differences, but also the different legal and policy frameworks that are different from the two countries where the crimes are committed. So that's really a series of capacity gaps that can be addressed. I'm not really know exactly which capacities will be addressed. But once we have the findings from the capacity gap assessment, then it'll be fixed to see where to go. But I think it will be really needed. And according to what even my sister said, when you come to capacity building of the mediators, it also require understanding what would be needed to mediate. And which person will be mediating, to understand what will be the needs in terms of capacity building. That will be that will be done in terms of building capacities. But capacity building require like a spectrum of skills that are not necessarily available nowadays. But that will be needed in the future too.
Will be needed in the future. I like the aspect of the creating solutions or directions that are informed by research. And this is very important that there's that research or that study going on, and then probably we'll come again and now discuss what did we find out and what is the roadmap. But Deja, I want to ask you, this policy or these policies in terms of the ADR, have they defined which cases qualify for mediation? Does it give guidelines on which ones? So that we are not seeing people who have committed very heinous crimes. For example, on this show, we've had, defilement cases where a child is defiled by a relative, a father who's supposed to protect them. And then the family decides, no, this we will solve it amongst ourselves because we don't want the shame of the family. Does that qualify as alternative dispute resolution? Are there any specific cases that the policy points and says, XYZ cases, someone stole your chicken, that one you don't need to go to court? XYZ, maybe just giving you examples, Deja.
That is a good question that actually I faced wherever I engaged audiences.
Yes.
Among youth, local leaders, everybody has asked the same question.
Yeah.
And the response is this one. Mediating or mediation can apply when you look at the two policies.
Yeah.
Definitely mediation can apply and support resolving conflicts in the family matters, administrative matters, commercial matters, construction, and all civil, commercial, and administrative matters. And at this level, we do say that we will slowly explore the way to applying mediation for restorative justice purposes. And in this, we go slowly. Why? Because it can't apply to all crimes. When we talk of crimes, we pay attention because of the gravity or the size or the nature of the crime under concern. And at this level, what the law on Criminal Procedure Code has allowed is to see crimes whose penalties do not exceed 2 years imprisonment can be subject to being negotiated between the prosecutor and the suspect, especially when the suspect plead guilty. There are two processes. The one is the guilty plea. The guilty plea is a simple procedure through which a suspect simply admit that
they committed the crime.
Yeah, I committed the crime. And I do talk of plea bargaining. Plea bargaining is a second version through which not only the suspect proceed by guilty plea, but also provides much more information on the way the crime has been mingled, prepared, executed, provide information on accomplices, on where outcomes of the crime have been, for instance, hidden, and much more information. The prosecutors are now allowed to negotiate with the criminals and bring a kind of an agreement between the two to the judge. But the judge is not ordered to receive everything.
Yes.
The judge, again, examines and decide upon, diffuse, or he can agree with, or refuse, simply banish everything.
Yes.
So far, crimes whose penalties do not exceed the 2 years imprisonment can be subject to being negotiated in terms of wherever the suspects are pleading guilty and they're providing for much more information.
Yeah, for clarity purposes.
For clarity purposes, yes.
Help us understand this. It's a chicken and egg situation. What comes first? Do we start finding alternative dispute resolution mechanisms ourselves, or must we first go to court and then the court is aware that this issue is being sorted from outside?
For
What
civil, administrative, and labor matters, we can negotiate.
Without going to court?
Absolutely. And go to court
when all options have been exhausted?
Absolutely. And for criminal matters, we have to avoid dealing with crimes in private. We have to let public officials get into game and support us in negotiating or not.
Good. I wanted to make sure that we are clear on that. So that people don't say, oh, but we were already discussing this, we were fixing the issue.
Yeah.
So it's good to know what comes first. Bernadette, I want to ask you, what's been your biggest, I think we've talked about the challenges so far, but what has been your biggest success in the work that you do as a mediator that probably can motivate and encourage others who've been just seeing trouble, who've just been seeing challenges? What's your biggest success story?
For me, I work as an ADR expert, designing systems, and we started to think about this ADR and mediation with Kigali International Arbitration Center, which is a center that provides arbitration services, but also all other ADR mechanisms. And when we started in 2012, this center, we started by designing and organizing arbitration services. And 2 years later, we told ourselves, well, we need also to start with mediation. We train some people and we invite, we organize a mediation week. And we made a public call for people who need help to resolve to be mediated.
Yes.
And nobody responded. And that's why we thought about there is something going wrong. And after some research, we realized that it's important to start within the court system so that judges start giving the message that there is litigation is not only not the only way.
Yes.
The only way of resolving a dispute.
Yes.
There are other options, so try them. And since we started this court mediation system,
Yes.
now we are seeing changes because the number of cases that are being mediated are increasing.
Right.
And if in civil matters, figures we have show that cases are in court for an average between 7 and 30 months. And some court now has started, if they can't give you that is near, they suggest you to mediate your case instead of waiting 10 months, 12, a year, 2 years. They told you, if you accept mediation, we can help you resolve the case. And now we see the report from the judiciary every week. Courts are mediating cases, and slowly people even are coming at court asking me, I filed this case, but I want to be mediated. I don't want to wait.
I don't want to proceed further.
And with the training, with many people who have been going through the program, the capacity building program, there are also ambassadors around them, lawyers, many lawyers, legal officers, in-house counsel in the private sector, particularly banking sector. So there is this paradigm shift that you can observe now. I'm sure you look at those moments as proud moments, seeing how far you've come. I want to ask you a question, Jean de Dieu, but before that, let me just quickly read some feedback that we are receiving so far on the program. We have Louise Businje, who says it's really commendable that Rwanda Ministry of Justice is keen on decongesting prisons and reducing the backlog of cases through the criminal justice and ADR policies. It might take a while to assess impact, but 3 to 4 years down the line, tremendous success will be noted through these reforms. This is a very optimistic gentleman over there. I have another one from Alice Tess, who says punitive justice is out-fashioned, and it's not. It is not. I think he says it is retrogressive, and it is also not retaliatory and harborous. Hey, this must be a lawyer. These words are very heavy. No. ADR people are judges, witnesses, and prosecution. It therefore limits corruption. It's not easy to bridge a huge
community. I think these are very interesting comments coming in here, especially on the aspect of building the trust in that case. I think I have a Kenyan here who's on Twitter and says it's called Esukari Dennis. Esukari is sugar. And he says, within the Kenyan culture, ADR remains widely practiced informally and primarily through negotiation and mediation, especially at family, religious, and community level. And I think we mentioned the role of these huge institutions or these players in that particular sense. And I want to urge all of us to continue sharing our thoughts. Keep talking to us. Let us know what your thoughts are. What has been your experience, especially in handling those particular issues from an alternative dispute resolution mechanism? I want to give us some closing thoughts, maybe the way forward, the future, where we see things going. And I want to start with you, Jean de Dieu, especially from a tech space. You know, this program, we speak a lot, and not in a week we fail to speak about the place of technology in all this. I know we're talking about resolving these things by sitting and talking to each other, but what's the end goal? What's the future looking like, especially within the dispute resolution mechanism that are alternative from litigation?
I think the future is to have all people understand the principle of mediation. Is conflict resolution mechanisms, but also is a tool to improve access to justice for all. Mediation is very cheap, not cheap actually, but not too much costly.
Yes.
It's also reconciliatory. It helps in terms of keeping the harmony among the people.
Yes.
So the future for me is to embrace the principle of the mechanism of mediation and criminal justice policy.
Yeah.
And with this, especially focusing on the general population.
Yeah.
We saw earlier that some people are still reluctant to use mediation services because they don't really understand what they can get from mediation.
So they should give it a try.
They should give it a try, and we see the positive impact they will see.
Right.
As in terms of using the communication channels that we have, I think that will be very crucial to engage, especially the youth, to promote mediation among the communities in general.
Yeah, Jean de Dieu, they're whispering in my ear, say, Eugene, we need to go. I told you guys it's the shortest 1 hour. But I want to give Bernadette another, like, let's say less than 30 seconds. What's the future looking like? Just what do you see in future?
I see the future of Rwandans that are really very enjoying those alternative dispute resolution. And what I would like at the same time to say, if we say that mediation is the best way for resolving dispute, we are not saying that we don't need court.
Correct.
We still need courts because the court set for us the boundaries within which we can interact in resolving dispute as citizens, as we interact in life. And we are in a process of adjusting our system. And now citizens now will enjoy this possibility of working together, engaging in a dialogue in resolving dispute supported by the court system.
Interesting. Thank you that you bring that. Deje, very briefly.
Very briefly, I may say that the future of Rwanda in the future of mediation and alternatives is brighter. This is said looking at the way people have started being mobilized. Both judges, advocates, people into business, bankers, insurers, and as well as members of the community, civil society organization members. Everybody is mobilized to getting into alternatives. And from more than 20 years that I started working, I have never seen two litigants at the end of, I'd say, the pronouncement of the judgment, hugging each other. But she may testify. Today, we are observing people into a win-win situation. After 5 years or 10 years, hugging each other, rebuilding peace and love in relationships.
Thank you, Deje.
Thank you too.
We need to go. We are safe. And if we have crossed the line, I'm sure we can we can mediate, or we can have a mediator to sort us out with the person coming in to anchor the news at 10 p.m. So we want to say thank you for making time. And we'll see you again next week, same time, same place as always. My name is Eugene.
Anangwe.
Thank you very much.
Thank you.
It's a wrap.